chaotic, rambling, non sequitur, out of control, insulting, sort of unprofessional, inappropriate testimony.
Hi everyone, Dave Sugden of Evidence at Trial. So let's talk about it. Let's talk about Donald Trump's testimony in the civil fraud case now pending in New York. Now, according to Rachel Maddow and numerous other sources, it was an utter disaster for the former president, where he was unhinged and belligerent. On the other hand, other outlets described Trump as aggressively defending his business record, and then it was the judge who was out of line. So which is it? And if you're the examining attorney, what do you do with a witness like Donald Trump? Thanks to Dan Frumpkin of Press Watch, who made Mr. Trump's trial transcript available online, we're able to actually read exactly what was said by the former president instead of relying on second-hand accounts from folks who might have some strong feelings about the former president one way or the other. And in the transcript, there is a lot to unpack. There were truly some bewildering moments and a lot to learn for the practitioner, so let's get into it. To set the stage, the plaintiff called Donald Trump in their case in chief. This is their witness. Their goal, to discredit the former president and show that he fraudulently overvalued his properties and assets to do two things. One, get favorable interest rates from banks and favorable insurance policies from insurers. Now, the judge has already granted summary judgment in the case in favor of the plaintiff, and the trial now is about damages. So much of the examination of Mr. Trump was theater, but there are still some hugely important takeaways from the examination. Because the plaintiff called Donald Trump as a witness in their case, he was their witness, meaning the general rule is direct examination. But he was also an adverse party and a quintessentially hostile and non-cooperative, uncooperative witness. And we see these types of witnesses in civil litigation all the time. Non-cooperation can take many forms. There's the witness who can't recall a single thing. There's the witness who doesn't seem to understand any of the questions being asked. But there's also the witness who's essentially a windbag. This is the witness who will provide long and meandering answers that are designed to evade the question. This is the witness who, if asked to state what time it is, will first talk about his watch. He'll talk about the watch store where he found his watch. He'll talk about how he likes to check the time throughout the day, and he'll talk about how beautiful his watch is, all the while never actually answering the question, what time is it? And even when the answer is brief, this witness will provide non-responsive answers. Mr. Trump, for example, was asked whether he agreed with the position of the Office of the Attorney General that the values in his financial statements were overstated. His answer, I think she's a political hack. So not exactly responsive. So what did the attorney for New York do with Mr. Trump? And significantly, what could he have done with the former president on the stand? New York's Guide to Evidence provides that when a party calls an adverse party or a witness who is hostile or becomes hostile, the court may permit leading questions. Leading questions are imperative for the hostile, non-responsive, non-cooperative witness. And yet, in the 200 plus pages of testimony, there's hardly a single leading question in the entire examination. In fact, not only do we not see any leading questions, the transcript is full of open-ended questions that specifically invite a narrative from the former president. For example, we see a series of questions that begin with why. Why, Mr. Trump, did you do this? Why, Mr. Trump, did you do that? Now, it's not that asking why has no place in a cross-examination, but when it's used, it has to be for a specific strategic reason. And with a witness like Mr. Trump, the moment you ask why, you're giving him the floor. You're giving him the floor to provide a very open-ended narrative without any guardrails. For example, he was asked, why did you make yourself trustee? Why did you remove yourself as trustee? Why did you select Mr. Weiselberg to be a trustee? All of these questions gave Mr. Trump a ton of leeway to explain something, to explain why he did something. And the attorney is yielding control of the examination to the witness. And that is exactly what happened. It wasn't asking OJ to try on the leather glove, but it was in the ballpark. The lawyer simply threw out these questions without having any idea what the witness would say, what Mr. Trump would say, and as important, no effective way to keep the former president in line. And that's what happened. With these open-ended questions, Mr. Trump provided open-ended answers. But it was not just why questions. Mr. Trump was asked a series of questions that were painfully broad. For example, he was asked about the reason for appointing Donald Jr. as a trustee, and he was asked, okay, anything in particular that was happening in July 2021 that led to that decision? Anything in particular? Well, the lawyer got exactly what you would expect. Mr. Trump testified, well, other than you and about every other Democrat, district attorney, AG, and U.S. attorneys, etc., were coming after me from 15 different sides, all Democrats, all Trump haters, all cases that are not good, that are inappropriate and not good. Weaponization, they call it. And so it went. But it did not have to be this way. As practitioners, with these types of witnesses who want to get their message out instead of answering questions, you need to ask tight and narrow leading questions. So, for example, Mr. Trump claims that regardless of what his statement of financial conditions said about the value of his properties, according to his testimony, they weren't, quote, badly needed. Because one, the banks and their lawyers and their appraisers did their own due diligence, and two, his statements had a disclaimer clause that told the lenders to do their own due diligence. However, the evidence also showed that the loan documents specifically required these statements. And Mr. Trump previously testified in his deposition that he paid a lot of money for their preparation. So, when Mr. Trump offered up that they weren't, quote, badly needed, there was a great opportunity for a tight cross-examination. The prosecution could have asked, even though, Mr. Trump, you claim they weren't badly needed, they were specifically required by the loan documents. Isn't that true? And if he says no, you then go to the document. Once you have this concession, you then ask, and even though you claim they weren't badly needed, you yourself have admitted to paying a lot of money for their preparation. Isn't that true? And again, if he denies it, you go to his prior testimony. Instead of this, the examining attorney asked, when you say they weren't badly needed, what do you mean? With this open-ended question, Mr. Trump gave a long-winded explanation about the disclaimer clause, how the banks don't really pay attention to them, and how they weren't important. Rather than moving on, Mr. Trump was then asked, how did you know that the banks did not pay much attention to your statements? And again, with this non-leading, non-challenging question, Mr. Trump teed off, beginning with, because I have been dealing with banks for 50 years, and I probably know banks as well as anybody, and he just went on from there. And this is the danger of non-leading, open-ended questions, and this danger is compounded with a witness like Donald Trump. These questions may have been appropriate in Mr. Trump's deposition, but they had no place in trial. If and when you have such a witness, you need to ask leading questions. We lawyers, we have just one tool in order to do our jobs, and that tool is the tool of asking questions. And with a non-cooperative witness, we have to lead. Folks, I hope this was helpful. If it was, please like, subscribe, hit the notification button. If you want a topic covered, leave a comment. And if you want to do a really deep dive on these evidentiary concepts and how to apply them during trial, check out our online course page at evidenceattrial.com. Thanks for watching.